if it's a debt buyer, basically most of my clients are comfortable with giving me money to defend the case because they either withdraw it or I win the case, you know, most of the time or pretty much all the time. And that's the end of it. They don't have to worry about it. And it's amazing how people say, what a weight that is off my shoulders over this $1,000 or $2,000 lawsuit. Well, to us as lawyers, it's a lawsuit. What's the big deal? But to most people, I've never been sued before. I can't believe this. And they've been stressed out over these debts for a long time. So you know, it's nice to see when they feel good and they feel free from this. I just did a case downtown where we worked the deal out, and it was a case I probably would have won. It was a debt buyer case, but we got such an incredible deal I couldn't refuse it. And I got the nicest thank you note from this lady and from her husband. You know, it just took all this stress away, and I'm like, really? But that's the way it works. So it feels good to do that. So what happens is because, you know, if it's a $10,000 case, you're going to charge more for that, but the question is, should you file the preliminary objections or not? And some lawyers just say, look, we filed the answer. It's a debt buyer case. You have affirmative defenses to, you know, that there's no privity with the under the contract. They don't have the assignment. They don't have standing. And of course, the statute of limitations, you know, especially if it's something out of Delaware or Virginia that also has a 3-year statute of limitations. The other part of it is discovery. What happens is they like to do a little bit of tit for tat. If you send them discovery, they're going to send you discovery. So you kind of want to avoid that, and it also creates more work. But I got a case now where it's a young lawyer, and he's been very arrogant. And I've talked to a few other people that had to deal with him too, and he was threatening me. Your client, you know, they're denying this and that, and they got to be lying. Well, the client, he can't figure out from his complaint whether it's their card or not, so we answered it appropriately. Then he says he demands a deposition of my client. So I said, fine, you can have the deposition, but bring in your affiant, the person that verified your complaint. And so then he's like fighting with me. You have to send me a deposition note. You have to ask for, if you want to depose a corporate designee, you have to give them the scope of what you're going to examine them on in a deposition. Well, I said, this is not a corporate designee. This is the person that verified the complaint. They said they're an employee of your company. Bring them in. And I've run into this a few times. And what happens is, all of a sudden he went away. He goes, well, they're not a traveling employee. Now, I litigated this issue. I mean, they're not a traveling employee. They sit in a chair all day. They go to the bathroom. They don't move. I don't understand this. Yeah. What is this? So there was a case that I had a couple of years ago. It was actually in Bucks County, and it was Discover Card of all places. And the person that verified the complaint was out in South Dakota or one of those places, and they just fought me on this, and the judge ruled in my favor. I filed a motion to compel deposition. They came back with this thing. Well, they're not going to come because they're not a traveling employee, but we're going to bring this other guy up from Delaware. And I wrote back and said, I already deposed that guy. I don't want him. I want her or the guy out of wherever he was from. We ended up settling the case, and it was a really good settlement.
So what is your stance on to PO or to answer? What do you?
It depends on the case. It depends. If it's a debt buyer case, typically I'll PO it. If it's a original creditor case, you know, I might just answer it, because why force them to dig up documents? I mean, they're just going to go out of their way and say, okay, I'll get the documents. And believe it or not, there's many times where they don't produce the documents for the arbitration. So, you know, that's kind of what I do with that. As far as depositions, you know, this other guy now has now disappeared. Now, I could press this and really force him to bring his guy in, which I suspect will result in him ending up dropping the case because his client doesn't travel for some reason. So I don't know. It's the most bizarre thing I ever heard. Well, you know, and can you imagine going in front of a judge here? Well, judge, my client doesn't travel, but they have no problem signing thousands of verifications and suing people in Pennsylvania. How do you spell robo-signer? Okay? So you put in your answer, your new matter, statute of limitations amongst them, and you basically use their exhibits against them. And then I'll finish up with this. Do you counterclaim or not? You can counterclaim if, under the FDCPA, if it is a debt buyer, and we'll talk about who you can sue under the FDCPA in a second, you can counterclaim them. They cannot remove the case to federal court once you counterclaim them if they initiated a state court. If, on the other hand, if you initiated a case in state court under the FDCPA, the federal court can exercise concurrent jurisdiction. The debt buyer can remove the case within 30 days of being served with the lawsuit. So a counterclaim is a good strategy. I have a case right now where the original credit card company has sued my client, claiming that he defaulted on the credit card payments in 2009. I have all of his statements. He's paying. He's in pay status. So I counterclaimed under the Pennsylvania Unfair Trade Consumer Protection Law and some other breach of contract, and said this is a bunch of baloney. He's now incurred attorney's fees, and now this law firm has now filed preliminary objections to my counterclaim, the second set already, saying I don't have a case here. Well, I think I have a case, but that's the problem. Now we're just litigating and litigating and litigating. The lawyer for the original lawyer for the credit card company, the collection lawyer, had to get out of the case because he goes, oh, once you file a counterclaim, I don't defend. I just sue. Because then I get to charge an hourly rate and I don't have a deal with it. So he's out of the case, but I'm probably going to sue him because my client was smart enough to notify him and show him proof of the debt, that it wasn't a debt, that he didn't default. He also has misinformation in the complaint, so I'm probably going to sue him under the FDCPA. So it's a very interesting issue. The counterclaim just muddies up the water. I don't think it really necessarily gets you too far in many of these cases because you really don't need to do it.
Excuse me, did that cover statutory damages with the counterclaim? Like if
Under the Pennsylvania Uniform Trade Consumer Protection Law, or Unfair Trade Consumer Protection Law, you get triple damages of what your ascertainable losses are. So the question is, was there an ascertainable loss or not under that statute? And you get attorney's fees. The problem is it's discretionary, because if it wasn't discretionary, I'd bring a slew of lawsuits under it. Now, when I file my fair debt collection suits in federal court, I throw in the Pennsylvania statutes because it mirrors the FDCPA, and it says if there's a violation of the FDCPA, it's also a violation of the UTCPL, and also something called the FCEU, which is the Fair Credit Extension Uniformity Act, which is another version of, another way you go after debt collectors. That's actually the FDCPA of Pennsylvania, the Fair Credit Extension Uniformity Act, but there's really no damages under it. It says the damages are the same, the ones that you get under the UTCPL. It's a very poorly written statute. Our consumer laws in this state are below mediocre. I had a case where I was going to sue somebody. It was a debt relief company, and so you look on the federal docket under PACER, and I saw where this guy in Missouri had sued this company, and I'm looking at his complaint. They get 100 times damages. So I called him, and I said, well, tell me about this. He goes, oh yeah, it's a great statute. He goes, they buckled right away. But we get triple, and it's not mandatory. It's mandatory out there. So I figure, you know what, it's not worth it. Anyway, if the creditor wins, and now it dovetails with the FDCPA, the creditor can't attach wages under most circumstances in Pennsylvania. In Pennsylvania, you can only attach wages if it's certain kinds of student loans. If it's a landlord-tenant judgment against you, you can attach the wages. Or you can attach the wages of the person that the judgment's against. If it's child support, you can attach wages for that. But you can't attach wages for taxes, for IRS taxes and for Pennsylvania taxes. The creditors in a credit card case, in fact, any judgment creditor generally can't attach wages. However, these two cases, and I'm not going to go through these, basically state that if you took the credit card out in another state that allows for wage attachment, then you can attach the wages in Pennsylvania, and that's been affirmed by our Superior Court. And that's been fought like crazy, but it's a losing proposition. It goes back to some old Bucks County case
Yeah,
from
it was
literally
wondering-
like 100 years ago.
I was wondering what the rationale was, but I figure it's in the case.
Yeah, that's all you need to know. But these two cases, I just gave a little lecture on these, and they just came out. They're very recent cases, and they're not good for the debtors. Anyway, we have how to handle district justice cases. Somebody got a little smart and put the Supreme Court justice in there because we couldn't find any other pictures. We were looking for types of different clip art to put on there. I'm not going to go through that because we got to get into the FDCPA. So what is the FDCPA? It's the Fair Debt Collection Practices Act. It was enacted in 1977 to protect consumers from debt collection, harassment, and abuse. And unfortunately, they have not changed the statutory damages since 1977. What's the statutory definition of a debt collector? Original creditors are excluded. I get people calling me all the time. You know, HSBC, they're horrible. But they call, even if you're not late on your payment, because it's kind of a high-risk credit card, they will start calling you days before the payment is due to remind you. But they call you 10 times a day with these robocallers. So, you know, clients are calling all the time, or potential clients, I want to sue them. Well, you can do it under the Pennsylvania statutes. They don't shield the original creditor. But, once again, if you win, it's not mandatory that the judge gives you attorney's fees. And I'll tell you what really underscores that. If you file a petition to strike a judgment in Pennsylvania, and you're successful on it, it's mandatory that the judge in common pleas court has to award you attorney's fees. I've never been awarded attorney's fees, and I've had a lot of judgments stricken. So I try to stay away from this. So you go after the bad debt buyers. We call them zombie debts because I've had people who've been in bankruptcy, they've been discharged, these debts are 10 years old, 12 years old, and all of a sudden they're alive again, and they're back. And you would not believe how many people do not answer the complaint. They get sued, they're done. Or they get a phone call, I'm gonna pay you. Now, what's happening now is that there's a lot of these scammers out there, been going on for years, where they're calling people, especially the elderly, and they're saying, oh, you know, you owe us this money, and a lot of young people get these calls. You owe us this money, we're gonna send somebody out to your house, we're gonna arrest you, and the next thing you know, they're giving them, you know, $500, or they're giving them their credit card account, or not the credit card, their bank account, the checking information, and they're getting paid, or they're paid by a debit card. And then you can't find these people. And we have actually, we've encountered a couple of pretty radical situations where we've talked to the FBI, we've talked to the Attorney General's office, we've talked to the police, we've talked to the local news stations. Nobody can do anything about it because a lot of these scammers use the voice over internet thing, and you can't trace where the calls are coming from. Lawyers are liable if they are in the regular practice of collecting debts under this Heinz v. Jenkins case from 1996. So if in a pleading, and here's an example of a case that I had, the law firm sued the client based on behalf of the original creditor. They said the client owed $10,000. I came into the case, I filed preliminary objections, I filed an amended complaint. Before I came into the case, and this is a matter of weeks, the client sent them a check for $1,500, something like that. And the client thought, oh, I was gonna pay off the whole thing. You know, so I came into the case, they amended the complaint, and they said the client still owed $10,000. Guess what? They got sued. They settled. Because in the FDCPA, it's a fee-shifting statute, and it's federal court, most of the time it's a federal statute. It is mandatory that if you win that case, even if you get $1, the other side has to pay your attorney's fees. So they're paying their attorney's fees, and if you're successful, they'll pay yours. I try and filter out my cases. Once in a while, I make a mistake, it's a clunker, and I'll withdraw or dismiss the case, or we'll settle it for, you know, something less than what I want. But most of the cases, we try and make sure that the cases we bring actually are good cases. The problem we run into is that the federal judges have really been stuck with their federal statutes, they don't wanna deal with cases that are worth $3,000 to $5,000 or $10,000. You know, and I don't think the statute was meant to, you know, clog up the federal court with small cases, but the federal courts probably should set up like a separate, I think some of them have separate, you know, divisions that'll just handle these smaller cases. So the federal judges, not all of them, but, you know, by and large, you know, my impression is they look at these cases somewhat as a nuisance, but they do take them seriously. You know, there's a lot of really good opinions, and a lot of good opinions that have come out of the Eastern District and the Third Circuit, where they've really looked at these cases under a microscope, and they've been very, you know, I can't say they're like pro or anti-consumer, but it's been a lot of favorable decisions for the consumers. So even though they're not the type of cases, you know, it's not like you're going in. Major League Baseball does all their litigation practically in Philadelphia. I think the NBA does a lot of litigation here. You get major cases coming through our particular district court, and now you walk in with, you know, a $3,000 FDCPA case. So you can imagine how, you know, the judges may feel about that. Car repossessors, they come under the FDCPA. If they come in and they disturb the peace, you tell them to leave your property, they don't do it, you could sue these people for doing that. And then your customary debt collectors, you know, your NCOs. They're the biggest debt collection agency in the world. They're out of Horsham. They get, if you look on the federal docket, there's like an amazing amount of lawsuits against them, but that's probably more a function of their volume than it is anything else. So they're the people that we typically go after, and you know, there are some other entities out there, but it's not worth getting into. Definition of a debt under the FDCPA, it's any transaction, financial transaction for personal, household, or family use. So even if the credit card says, you know, ABC Business Inc., and you use that card mostly for your personal stuff, that comes under the FDCPA. So it doesn't necessarily matter whose name that card is titled in. I had a case a few years ago, and we settled it for less than what I wanted, but my client had sued, I sued one of the debt buyers, I forget who it was, but you know, the guy calls me, and I knew the lawyer out of New York, and he said, you know, this is like a Mary Kay card. Your client's a Mary Kay rep. And she's selling her Mary Kay stuff. It was all through this card. And, you know, I said, well, yeah, I know that, but she told me that, you know, and her and her mother were buying Mary Kay products for themselves. They weren't really selling it. So I didn't want to get into a big fight over that. I thought, you know, a judge is probably going to look at me sideways, you know, after hearing that. And, you know, so we compromised on that one. Who can sue? Well, first of all, communication is, you know, phone calls, letters, anything directed towards the consumer. There's a lot of litigation on this. There's a lot of decisions that say, hey, even if it's directed at your attorney, it's not directed at you. So even if they lie through their teeth talking to me, that doesn't mean that my client, or sending me a letter, that doesn't mean that my client can sue them. So typically, generally, it has to be a communication directed at the consumer, voicemail messages, you know, and we'll get into phone calls to neighbors and relatives. I get a lot of calls where the clients say, they told my wife everything, I didn't want to know about the credit card. Well, too bad. They actually are allowed to talk to spouses. So if you're hiding anything from a spouse, if you're married, and it has to do with a debt, you know, they can talk to your spouse about it. The best part of the FDCPA is anybody going into it is considered to be the least sophisticated consumer. So if Bill Gates was the subject of a debt collection effort, Bill Gates would be looked upon as though he was the least sophisticated consumer. So that's a good standard, because other than that, you know, they're going to come in and say, well, this person was too sophisticated. They understood that. What's amazing to me is how many calls I get from people that used to work for collection agencies and know how this works, and now they're being harassed. And, you know, the best case out there, and I can't remember who it was this convicted mob enforcer loan shark. And he's in jail, probably for the rest of his life, out at Rikers Island or one of these places in New York. One of the big debt collection agencies sued him, and were trying to collect a debt against him. despite the fact he had spent his entire career trying to collect debts against other people, albeit in more harassing and abusive ways. 1692G, validation notice. Within 5 days of the first communication with a debt collector to you, which typically would be a phone call, they have to send you a letter telling you that this is an attempt to collect a debt, any information will be used for that purpose, and informing you that you can dispute the validity of the debt. Now, people call me, and once again, they go, I disputed the validity, and I asked for all his documents, and all they did was give me the name of the original creditor, if it wasn't on the original paper, or if they didn't send it through the mail to them. And they gave me the name of the original creditor and the amount of the debt. Well, that's pretty much all that they're required to do. But during that time, when you're disputing it, it's a 30-day window that you have, they have to cease further collection activities. And if they don't cease the activities, although filing a lawsuit is not necessarily considered a collection activity for some reason, there's some split decisions on that. But if they don't cease the collection activities, then you can sue them under the FDCPA. Interestingly, if you do not dispute it, it doesn't mean that you're liable. And there's a section in the FDCPA that specifically says you are not considered to be liable if you don't dispute it. And I've been to court, and I've had some of these debt collector attorneys say to the judge or the arbitration panel, the fact that they didn't dispute the debt shows that they're liable. And what I do is I have a packet, I bring it to court with me, it's got all the relevant cases and statutes, and I just bring it to every case, and I pull this out and say, Judge, here's what the law says. In fact, just by them saying that in court, that may actually be an FDCPA violation. I haven't tested that yet. But I'd say that to the judge, that's a violation right there. Anyway, they have to state the amount of the debt in the initial letter. As I said, if it's disputed, it has to be reported as disputed. And if they don't report it to the credit reporting agency as being disputed, that's an FDCPA violation. So we encourage our clients to go get that free annual credit report. The problem is they get the report and then they want us to read it and analyze it for them. So it sometimes gets a little cumbersome. The 1692G notice can't be contradicted by other language. It's called overshadowing. It's got to be in a certain font. It's got to be prominent. We have cases where they've sent the letters and they've intermixed English and Spanish, and it's confusing. We have some right now that Brandon and I are looking at where they've sent 3 letters to my client in Spanish, and she's anything but Spanish. I mean, her name, I guess, would sound, like it might warrant a letter like that, but she's not Hispanic. There is a little bit of English in it, the name of the company and the phone number, so we're doing some research to see if that's a violation, because they keep dunning her in Spanish. So she's not really getting the notice to dispute the debt in a prominent way that she understands. It's being overshadowed by the Spanish language there. So, you see all kinds of stuff. There's some decisions that gave the debt collectors what they call safe harbor language, that gives them actual language that they can use. It's cut and paste. They don't do it. I don't understand it. The courts have said, use this language, you'll never have a problem. You'd be amazed how they don't do it. And they tell them to put it on the front of the letter. A lot of them put it on the back of the letter. Say, see the back of the letter. So, and in the small font. And so I went over that different language and the font size. Let me go to the next one. Uh-oh, we're stuck. I think I need your help, Tom.
Sure.
Anyway, I have that here. Let me pull that out. So there's other violations that occur. One of the big things that used to happen was a lot of violations. There's 2 types of main violations. One's a letter violation, where they have stuff in the letter that they're not, they're not allowed to use, or they forget to put the language we're attempting to collect the debt. But here's a big one. They have implied or expressed threats to file a suit, or they threaten to file a suit on a time-barred debt. If it's beyond the statute of limitations, you can't do that. You also can't, let's say the debt's $80, $100, $200, and they don't sue on things like that, on debts that low. You can't threaten to file a suit. You know, we're gonna take legal action. And you can find out if they file suits. You look in your county dockets and see if Asset Acceptance files suits on $200 or one of the law firms. And generally, they don't do that, so you can sue them for that alone. Threatening criminal prosecution's a no-no. Misstating the liability. I have a case now where my guy, he's a foreign national. He doesn't speak English great, but he understands enough. He comes in and says to me, they told me I owe $20,000 and some odd dollars, but they sued me and it only says $10,000 and some odd dollars. So I said, call him. Well, I could hear through the phone. I wasn't listening in. They're giving him this $20,000. They then send him a letter saying you owe $20,000. We go to court, it's $10,000. Well, now it's in suit. So they misstated liability. They a lot of times you see, you know, they're gonna sue you within a short period of time, or you have to get back to us within 7 days, or we're gonna take legal action, and then they don't take it. That's grounds for a lawsuit. Threats of a suit by attorney not licensed in this jurisdiction. I've had several cases like that. We're gonna sue you. Well, you know, you're out in Colorado or California. So I look to see if they're barred in Pennsylvania. They're not. They can't threaten it. We're gonna recommend suit to our client. Well, once again, that's code for we're gonna sue you. You could, you know, collection agency, they threaten to file suit. Unauthorized practice of law. The wrong forum, they can't even threaten to file somewhere where they can't file a suit. Threats to enforce creditor remedies, which can't be enforced. I get a lot of cases where we're gonna garnish your wages, where they're not allowed to do that, or we're gonna report this information to the credit reporting agencies in a manner that's prohibited by the FCRA or FDCPA. There's a lot of threats that they make as far as reporting that they're just not allowed to do. There's a lot of threats to contact employers. If you tell them that they can't, that it's your company's policy, that you can't receive calls there, collection calls or personal calls, they gotta stop calling. Generally though, if you tell them to stop calling you at home, they can still call you. You have to send them written notice, and I have my clients send it out, certified mail, return receipt. If it's only a post office box on the other side, you send it certified mail and regular mail. There you go. So the other thing is, I thought it was on here, it's third-party contacts. Yeah, I think it is. A lot of times they'll throw interest and late fees, expenses, service charges, and they have no basis for it. They have no documents showing that they can do that. Now, you don't always know whether they have the documents or not, but 9 times out of 10 they don't have it. And sometimes I see letters that say other charges. Well, that's a lawsuit. What do you mean other charges? We don't know what that is, and that's deceptive. You can't have a deceptive practice. Something that can be read in more than one way is considered a deceptive practice under the FDCPA. Attorney's fees, where they ask for that without having a contract. Hidden charges. A lot of times they try and describe the principal balance. They'll include interest and say, this is the principal balance. Well, it's not the principal balance. The problem is a lot of the courts around the country have said, we're not going to consider that a violation. I think it's a violation, but the courts have said otherwise, and they're the ones that rule. Or they'll call it the account balance, and it really isn't, because they're including other charges that shouldn't be in there. Inability to prove what is due. It all depends. If they're throwing interest on there that they shouldn't have, then that is an FDCPA violation. There's a lot of cases where attorneys have sued the collection agencies or the debt collectors, saying that they've come to court, they don't have enough documents, that they file a suit and they can't even show they own the debt, and the courts have generally sided with the creditors, with the debt collectors on those cases. Collecting bankruptcy discharge debts, can't do it. That's a no-no. Now that becomes a little weird because there's a dispute between jurisdictions over different courts as to whom has jurisdiction over that. There's several circuits that say, well, the bankruptcy court has jurisdiction over that, not the federal court. Well, that means that you have to go back in and reopen your bankruptcy in order to prosecute it. Well, who wants to do that? David does bankruptcy, I used to do bankruptcy work. The clients want to run away from their bankruptcy discharge as fast as they can. So the last thing they want to do is go back into court to to prosecute a case like this. 1692E, false representation of communications from an attorney. They love that. We get these letters all the time from lawyers' offices that say, at no time has an attorney reviewed your account. Well, then what are you sending me the letter for talking about the account? It makes absolutely no sense. Voicemail messages, they've got to identify themselves when they call you. And if they don't identify themselves, then that's a violation of the FDCPA. And even though Pennsylvania is a two-consent state where you have to get their consent to record any audio information, it's not when they voluntarily leave a voicemail message or any audio recording, whether it's a tape machine, they don't even have tape machines anymore, whatever the device is. So the bottom line is that that's an area which is really good, because then we tape the recording and we use it in court. We actually transcribe it. We throw it in the complaint. Say, look what they did. They didn't say who they were. Now, if they call your neighbor, they can only call once to confirm location information. And unlike leaving a message at home, they can't say that they're a debt collector. So if I'm calling from ABC Debt Collection Corporation, I do have to say to the neighbor, I'm John Doe, and I'm just calling to look for Jane Smith's, I'm confirming her location information. Is she still living at so-and-so? Then if they say, by the way, tell her to call me, here's my number, that's it, they get sued. You can't go beyond that, and they do it all the time. What they used to do, and I haven't seen this in a long time, is they used to have what they call block parties. They call all your neighbors and your relatives, and they would just do it to harass you. And that practice has really gone out the door because of some, class action lawsuits. They can't use the creditor's name if that's not the creditor they represent. A lot of times I see the debt buyers saying, we're calling about a GE Capital debt or Capital One debt. Well, that's not you don't represent them. That's not your account at this point. You have to call and say you're, ABC junk debt buyer. Legal action to enforce interest in real property only where it's located. I talked about that already. They can only come after you, where you live and where you sign the contract. They can't put extraneous material in envelopes showing that they're from a debt collector. So if you get a letter that says ABC, debt collector on it, and you don't see this anymore because they got sued so many times, because you can't communicate to other people that the person that you're targeting to collect from owes you a debt. It really goes to invasion of privacy, and the FDCPA has addressed that. They can't put false statements in pleadings. They can't give you false representations regarding tax consequences. If you don't pay this, you're going to owe all this money. The complaints have been on the rise with the Federal Trade Commission. The Federal Trade Commission has asked private attorneys to act as mini prosecutors for them because they don't have the resources to go after these people. So that kind of feels good that we have a little bit of government, consent there or whatever it is. Repeated phone call, you see the type of complaints, repeated calls, misrepresenting the debt, the character amount, or the status of the debt, no written notice. That's the level of complaints. I forget what it is, the FDCPA complaints, they were by far and away every year, or the debt collection complaints by far and away every year are the most complaints that are filed with the Federal Trade Commission. People call and they complain about products or services. These are the ones that really they get most of the complaints about. And so you can sue them for invasion of privacy, defamation. There's a criminal prohibition in Pennsylvania for failure to attach the assignment to a lawsuit, but it talks about collection agencies. So it's a little bit different. Collection agencies don't ordinarily sue, and nobody's really tested this to say whether a collection agency comes under the FDCPA. If under the Pennsylvania statute, a debt collector and collection agency are the same thing, because there's a distinguishing feature, and I've never seen anybody prosecuted for it. Remedies and procedures, I'm just gonna go through that a little bit with discovery. You want to find out the source of the debt, where they got it from, how the amount was calculated, documents giving the authority to the defendant to collect the debt. I've had, some of these companies go after my clients and, they can't really show that they even have a client on their end that allows them to come after them. They bought a list somewhere and they just decided they're gonna collect. Number of times that conduct occurs. When the court gives out the statutory damages, which is only $1,000, they're gonna look at the frequency of violations. There's been a lot of lobbying to get that bumped up to $5,000 for years, but it hasn't happened. However, you can get damages for emotional distress. And you do not have to bring in, you don't have to go for psychological treatment. You don't have to bring in a doctor to testify. You can say, my symptoms are this, I get headaches, I get anxiety, I can't sleep, I'm nervous. You can bring in somebody who knows you to testify to the same thing. Now, it leaves a better impression if you can bring in a professional to say, hey, this person is really screwed up from being harassed like this, but you don't have to do that. And then the amount of your award, you go in front of a jury, who knows what you're gonna get. You can get a lot of money out of that one. You get your out-of-pocket costs, attorney's fees, costs of defending a lawsuit. If the lawsuit was brought, it was a violation of the FDCPA. Let's say it's a statute of limitations violation. That's an out-of-pocket cost that you can recover from the other side. The emotional distress I just talked about, crying fits, nervousness, panic. One of the first cases that I heard of, and I've mentioned this to some people in the room before, was this lady who was a single mom, and the people left a message, the debt collector left a message on her phone, this was out in the Midwest, saying that, our agents are at the airport, and they're coming to your house to collect the debt. And you could hear, she then picked up the phone and called her mother and left a voicemail, and she was hysterical. The kids were screaming, she was absolutely hysterical. In my mind, because I watch too many movies, I'm thinking paratroopers are coming out of the sky, and they're coming over to her house, and they're gonna get that $2,000 that she owes. But in her mind, that's what happened, and apparently she got a huge award over that. So the court must consider the frequency and noncompliance by the debt collector, the nature of the noncompliance, the extent to which the noncompliance was intentional when determining the statutory damages. And they also look, when you're, I have cases where we haven't settled and we've had to go get a judgment against the debt collector, and the judge, you have to give them this whole package. It's a motion for default judgment. The judges, want to see all of this information in there and how much the debt collector really blew off the court, because they do that on those type of cases. The debt collectors have defenses, the bona fide error defense, but the courts have generally said, you know what, it's a bona fide error, but guess what? You made a mistake, but under the statute, it's a per se violation. So you rarely see that being successfully offered, although it can be. There's a really short statute of limitations under the FDCPA. It's 1 year from the date of the violation. But a lot of times you see continuing violations. So from each violation, you add on a year. Rooker-Feldman, res judicata, collateral estoppel. If the issues have been litigated in state court already through some other litigation, generally, you're going to be having problems. The word SOL for statute of limitations means something else, and that's what you're going to be if you bring your claim under the FDCPA and you are subject to one of those defenses. One of the things that federal court has, which is really a little bit tricky, is under Federal Rule Civil Procedure 68, it's called an offer of judgment. If you're offered, they can actually come in and say, all right, we're giving you $1,000. Let's say if a case that you think is worth $20,000 in damages, we're going to offer you $3,000 and your reasonable attorney's fees to be decided by the court when you make a fee application. If you don't take that, $3,000, and then you go to trial and you get $2,999.99, you're now liable for all their costs and fees. So it's a very powerful
From the date of the
tool.
offer.
Pardon me?
From the date of the offer.
From the date of the offer, that's correct. Thank you for correcting that. So you look at that, and, you know, you sit there and think, wow, that, you know, that's really tough. I rarely get an offer of judgment. You know, I think I value my cases correctly, and, you know, I'm happy with that.